Okay, so hi everyone. Welcome to our session tonight, titled Checks and Balances, the story of Chief Justice Francis Forbes and Governor Ralph Darling. My name is Gemma and I'm the Library Services Manager at the Society. And I'm also stepping in last minute for my colleague Vanessa, who you might have been expecting to see tonight, who unfortunately can't join us. So this event tonight is a partnership between the Society and the Rule of Law Education Centre. Before we get started tonight, what I'm going to do is just move on to the next slide. Oh, sorry. Sorry. All right. Okay. So before we move on to the rest of tonight, I would like to acknowledge the traditional custodians of country throughout Australia and recognise their continuing connection to land, waters, culture and support of storytelling. We honour their roles as custodians and practitioners of an unbroken history, culture and beliefs that began more than 65,000 years ago. And we pay our respects to elders past and present of the Gadigal land, and we extend that respect to Aboriginal and Torres Strait Islander people here tonight or who are watching the recording. The Society's offices, archives and library are located within Gadigal land, and I'm coming to you from Darug land tonight. So just a little bit of promo before we get started. So these are 3 events coming up for the Society in the next few days. Only up to next Tuesday. So on Saturday, we have the Caribbean Research Group coming up. That's this Saturday, the 25th of May, via Zoom between 10 and 12. And it should be a really interesting session because there are 2 guest presenters, Michael Flynn and Peter Day, who will each present case studies about their Caribbean ancestors. And some of you will know those people's names as well. On Monday night, we have the Let's Talk About series. So that's a free series for members. And this month's theme is Sacred Places and People. So that's Monday the 27th. Via Zoom again between 7:30 and 9 p.m. It's a really great lineup. I'm not saying that because I'm on the lineup, but there's some really interesting stories and really varied ones. So if you want to check out who is presenting and what topics are, you can find that information on the website. And then on Tuesday, 28th of May, I didn't include it there, but that is via Zoom as well. That's a Scottish research group, and they will be focusing on the historic county of Fife as well. So if you're interested, please feel free to go to the website and register for that one. Okay, then just some Zoom essentials. So many of you will be very familiar with this, but if you're not, you might like to add a comment to the chat, and I'll be trying to monitor that tonight. So the chat is a little speech bubble and may be in the center of your screen, but may also be over on the right-hand side. I have seen that recently for some people. And then also feel free to use the reactions button. So clapping hands or love hearts or whatever you like. Thumbs up, maybe if you agree with something that we're talking about, or if you have a question or something like that. Okay. So as I mentioned, tonight is a partnered session between the Society and the Rule of Law Education Centre. And it's really apt that we're holding this event this week because this is New South Wales Law Week and also the 200th, I believe, 200th anniversary of the Supreme Court of New South Wales as well. So we feel really privileged that our colleagues from the Rule of Law have offered this session tonight and to coincide with their new publication, which is titled the same as the session tonight and up on the slide for you. So in researching for tonight, I realised that I knew much more about my ancestors who were on the wrong side of the law. And so it was really interesting. I got to read a copy, an advanced copy of the book, and I just found it so interesting to learn about something that I probably should have known, but also in a very accessible and entertaining way. So I think that you will all enjoy hearing more about it tonight. So this brings me now to introduce our colleagues from the Rule of Law, being Sally Layson, the CEO, and Vice President Chris Merritt, who are going to tell us some more about this recent work and also more about the Rule of Law as well. So Sally, did you want me to start off with a question, or did you want to have a little chat?
Well, how about I give you a quick overview about the book, and then Chris might have a chat to you about a couple of things. We've got some questions, but so like we said, we've got an advanced copy of this is what the book looks like. Sorry about the lighting. I'll start this side. So this is our second book in a series. So I've actually spoken before to the Society about our first book, which was set in 1788 with the first civil case about the Cables family. And I know there's lots of Cables out there who we've spoken to. So I wanted to tell you a little bit about, I'll tell you about the Rule of Law Education Centre first, so you know who we are, and then I'll tell you a bit about our book. So we're a non-for-profit organisation that promotes the rule of law in Australia through education and public commentary. So we provide education resources to students all around Australia on the laws, the rule of law, judiciary, recent case studies, so help students identify what a fair trial is. And we also have Chris Merritt, who's with us tonight, who's our Vice President, and he writes in the Australian newspaper every week a legal commentary. So, and then Chris will, and if you have the Australian, you'll be able to see an article that's coming out tomorrow about this, but I'll get to that later. So I'll just tell you a little bit about our book that we've written. So this is what it is. And I want you to imagine that you're in the penal colony in 1788. Now, the penal colony at the time was a really tough place. It was a place of punishment, and it was the threat of transportation was meant to evoke terror in everyone in England so much to make them do the right thing. 30 years on, it comes to where our book is placed, and the things in the colony are looking quite different. The colony's been left to its own devices, and it's starting to look like an open, free colony. It's got convicts, ex-convicts, free settlers. And what's interesting about the colony at the time is that convicts can wander around freely. It's not, as you probably know, it's not a jail-like structure. They can have their own homes, they can have their own families, and sometimes they even had their own businesses. So our storybook comes in here, and the question is, what is this colony in the 1823 meant to look like? Is it a place of terror that just happens, terror of punishment, so people in England don't do crimes? Or is it a free colony that just happens to have convicts and ex-convicts living in it? Will the convicts and the ex-convicts have rights and freedoms to run their lives and affairs? So at times, I'm starting to wonder what the English government actually thought would be happening to the colony, because they sent two different men at two different times, at the same time, with two very different agendas to the colony. So the first man in our story, which you'll see here, is Governor Darling. So Governor Darling's a military man, and they send him to the colony to push the colony into shape. You can imagine just by looking at him, he loves giving orders and he expects everyone to follow him. At the same time, they send a second person to the colony, which is Francis Forbes. But he comes with a very different set of instructions. He comes to the colony with a new act called the New South Wales Act that's passed in England. Now, the act that Francis Forbes comes with puts checks on the governor's powers. It sets up the Legislative Assembly and the Supreme Court of New South Wales. It also gives Francis Forbes the ability to stop any laws that Governor Darling passes. And he's a check on the power. So if any of the laws that Governor Darling passes, if they're repugnant to the laws of England, Francis Forbes can actually stop them. So you can imagine at this time, Governor Darling thinks he's going to have lots of control, but then we've got Francis Forbes, who's got to check on his power. So our story keeps going, that invariably fireworks is going to happen between these two characters. And the fireworks happens with two soldiers who think life would be better as a convict than as a soldier in the colony. Now, you can imagine this doesn't go well. They steal some fabric, get with the intention of being caught. They get put in jail or lockup, and Governor Darling is mad. Remember, he's been sent to make this place a place of terror, and the soldiers living there go, no, it's better, I'm going to be a convict. So, of course, Governor Darling, the military man, goes, I'm going to make an example out of these two guys. I'm going to parade them. I'm going to send them off for 7 years hard labor. And legend is it, he puts these dog collar things on them with spikes that they can't sleep. He wants to make an example of them. He wants to punish them harsher than they should have been punished to make an example. He wants to make it so bad no one will ever do that again. But what he doesn't know is one of those soldiers was already sick at the time. So instead of 7 years harsh labor and then things be sorted, one of the soldiers, Suds, dies the next day. So we're in the colony. We've had these two soldiers overly punished, and then they die. At this time, the other thing that's happening in the colony is we have some newspapers. So a lot of you will know Wentworth came with his printing press with Wardell, and they came with their newspapers. And they, if you get a chance to read those articles, you should read them. Their descriptions are fantastic. They are ropeable with Governor Darling. He's a tyrant. He's not fit to run the colony. They let it rip against Governor Darling for overstepping what he should have done. He punished them too harshly. Governor Darling, back to him again. How do you think he's feeling about this commentary in the newspapers? A military man, he likes everyone to do what he wants them to say. And now the newspapers in this little penal colony in Australia is having a go at the governor. Of course, he's really mad. So he works it out. I'm going to write some laws and I'm going to cut the newspapers. I'm going to restrain them. If they say anything bad, I'll take their license. If they want a new license, I'm not going to give it to them. So he has this great idea to stop anyone disagreeing with him. But if you remember from what I said at the start, when they came into the story, we had Governor Darling with his instructions, get tough on the colony. We had Francis Forbes, who had some important legislation in his own pocket. That being, he was the judge of the Supreme Court, but also he could stop any laws that were repugnant to the laws of England. So Forbes has the option. He can pass the laws and let Governor Darling stop the press, or he can stop that. He's got a problem because he's got a governor who's writing letter after letter, trying to bully him, telling him that it's, the colony's safety is at risk if he doesn't pass this law. And he's at a time of immense pressure. So what does he do? I'm actually not going to answer that yet. But that's the important question that this book poses. Should Chief Judge Forbes pass this legislation that's for, in his mind, the benefit of the community and the safety, but it takes away the rights of the people? And so that's where we get to our book, and that's where the point we want students to look at is it's about the interplay between Governor Darling, Francis Forbes, and this is actually Wentworth, and how they all work as checks and balances on the governor. So that's my quick overview of the book.
Wow, thank you. I really want to know the next bit. Thank you so much. And then I guess the next thing that we wanted to ask was, as I said earlier, it is Law Week, and you've released the book for the 200th anniversary of the New South Wales Supreme Court. And I guess, why is that an important event to celebrate?
I'll jump in on that.
Okay.
Look, it's more than a birthday. Ostensibly, it's a birthday. Last Friday, to be exact, May 17. That was the date 200 years ago that the proclamation of the court was read out in Sydney 3 times, and Chief Justice Forbes' appointment was read out as well. So in the Banco Court in Sydney, in the Supreme Court, it's the biggest court that they have. There'd be about maybe 300 top lawyers, silks, attorneys general, hangers-on like myself, packed in there for a ceremonial sitting of the court. And it was really interesting that the current Chief Justice, Andrew Bell, made mention of this affair, this dispute between the first Chief Justice and Governor Darling. And the way the current Chief Justice saw it, he saw it in terms of the judiciary being a bastion for the defence of liberty. And that's exactly why this is important. It was a very unusual thing in those days for a court to be given the power to strike down law. And it only happened in New South Wales because you've got to remember from an historical perspective, New South Wales was the ends of the earth. It took a year to get a response to a letter. So the fact that Forbes was vested with this power to ensure that the laws promulgated by and regulations promulgated by the governor were in line with the laws of England, or more accurately, were not repugnant to the laws of England. That was an extraordinary power to be vested in a judge. English judges didn't have that power at the time. The only reason it happened was this extraordinary set of circumstances where England had a colony that may as well have been on the face of the moon. It was so far away. They simply had to vest power, extraordinary power, in the Chief Justice. Now, given it was an extraordinary power, why is it significance now? Because the judges in New South Wales don't go around knocking over statutes if they consider it to be repugnant. But some judges of the Federal Court and the High Court, or the High Court more particularly, do. They are empowered under our Constitution to do exactly that. But judges are also empowered in special circumstances to explain what the law actually means. Parliament passes a statute. It's not up to government officials to simply say, well, that statute means X, therefore I can do X. And for example, it's not up to a government official to lock someone up because in the view of a government official, a crime has been committed. The responsibility under the statute is for a government official to bring a person before a court, and for a court to, one, determine exactly what the law requires, and two, whether those circumstances have been met, and three, what the punishment should be. Now, we can see that happen if you look at it. If you look at what happens in the courts, not every day, but it's not uncommon to find that a government official turns up in court and they're very confident. They've issued, public statements about who's in the wrong, and then to be put in their place by a judge who says, look, I'm terribly sorry, but we're going to let this fellow go. The law doesn't mean what you think it means. And the most recent example actually happened last Monday, not Monday this week, but the week before. The Federal Court told an official of the federal government that no, your intention to require Elon Musk to do what we say he should do in all of his outlets outside Australia, regardless of what happens in Australia, but global regulation is what we're talking about. That I'm sorry, the law doesn't go that far. Go away and have a think about this again. So it sets, getting back to Francis Forbes, it set the precedent. It marked the point at which an independent judiciary, for the first time, took office and exercised its power on this continent. And the significance of this goes beyond New South Wales. You've got to remember that the Supreme Court in those days had jurisdiction that went the length of the east coast of this country, right down to Tasmania, stopped at Western Australia, extended out to New Zealand, and even included Tahiti, for goodness sake, and any islands in the Pacific or the Indian Oceans that were not claimed by European powers. So it was a significant jurisdiction that it had. And this marked the beginning of true judicial independence, which is a check on the power of the executive branch of government. In those days, the executive in the colony of New South Wales was Governor Darling. He was the representative of the Crown. He was a military man, and he conducted himself with all the self-confidence that he thought was due to his office. But once you have an independent centre of authority, such as a real court, not a non-judicial tribunal, but a real independent court staffed by judicial officers, the world changes. And the benefit of that is not the judges themselves, but individuals. You have contending centres of power. One keeps the other in check. And the beneficiary of that, if you think it through, are the people who are subjected to that power. If a court, if a governor or the executive branch of government, a minister or senior government official goes too far, misinterprets a law, exceeds their jurisdiction, we've now got in place and have had for a very long time, well before federation, the ability to pull up those officials and say, well, look, hang on, you're applying this law to this citizen in circumstances where you've got things wrong, I'm afraid. Go away, don't do this. So it's a defence of individual liberty, the liberty of individual people. You've got to remember the centres of power, these the courts, the executive, they're there to serve us. They're not there to serve themselves. And once you separate power out and provide a system of checks and balances, as is outlined in the title of the book, it benefits individuals. It protects individuals from abuse.
Thank you so much. And I think, as you said, it's definitely something that is, still exceptionally relevant and something that we hold dear in this country as well. I think that kind of that protection for the people that live here. Okay, we're going to move on and talk a little bit about the relevance of this publication or this book to the Rule of Law Education Centre. So a question for Sally, I guess. I'll start with the first part, which is, why has the Rule of Law Education Centre released this storybook?
So as I mentioned before, we are passionate about teaching Australian students about the government and laws and all the protections of their rights. So many studies over the last 10, 15 years have shown that Australian students, and New South Wales in particular, just don't know what the government, laws, what an independent judiciary are. New South Wales, we've been working really hard to fix the curriculum. We did a report 2 years ago that said a student could come through New South Wales with knowing nothing about laws, judiciary, because it's not in the curriculum. But right now they're changing the curriculum to include in the history curriculum elements of civics and citizenship. So if you live in New South Wales or you're a student, the chance for you to learn about what an independent judiciary is, what separation of powers is, what the Constitution is, all those concepts will now are covered in history. So that we found the best way to tell students about separation of powers is for them to be transported back into a time where there wasn't some of those protections and how they were created, and get them to understand that for themselves. So what we've done is we've written this book and picked it deliberately because it explains independent judiciary so well. Francis Forbes, at a huge personal cost, stood against the governor, and he believed that he had to be independent. And it's, as Chris outlined, the separation of powers is taught to students, but no one really quite understands what it is. They can tell you that it's 3 things, but to be able to really understand the value of it, you need a good case study. So that's why we chose to write a book, and it's not just be able to use in New South Wales, but around Australia, because we all look at separation of powers and the basis of how Australia is governed.
Thank you. And I think, as I said earlier, I obviously missed that bit of education at school, so I was very thankful to read about it. And so I know that this book is aimed for, I think it said years 5 to 9, and that's correct?
Yeah, that's right. So what it's aimed at in the Australian curriculum, you'll learn in year 5 to 9 about separation of powers, often in history or civics around Australia. And so what our hope is, and we have resources written by educationalists who look at, we've got case studies, we've got questions, we've got source documents. And what our dream is for students to be, it's called the case method. So you give a student all the materials that were available at that time, and they themselves have to make that decision. So where I left off the example of should Forbes pass the law, That is the question a teacher puts forward to a student. They give them all the material. They give them the newspapers at the time, the Australian newspapers, the letters that were written to Darling, the 1823 Act, and they look at the colony, and the aim of it is for students to embrace this and say, at that time, what should this decision be made? And it's that way civic understanding has grown the best, because they understand it from a personal experience. They themselves have had to debate this, and so they feel quite, they understand the value and how that would have protected the rights. And as Chris said, the officers that died and all the rights of having a governor that could do too much, this was often, when you talk about these things, it's external, but these are all about our individual rights, and they're all actually protecting us individually. And so they're things that students need to know, that an independent judiciary, even though they don't often see the courts and go there, it actually is one of their best protections. So that's why we've written it, and it's linked to the curriculum, because that way the schools will be able to use it. And so they'll look at it through separation of powers, and they look at checks and balances within the curriculum.
Thank you. Yeah, it definitely sounds like a very valuable resource, and I wish I could go back, I think, now and learn that way. I think particularly for, using the case studies and the different, documents and evidence and things like that. I think for family historians as well, that's kind of, how we do things. So I'm sure we would really appreciate that sort of.
Yeah, so I probably should explain what we have on the website and within the book is it actually tells the story using the source documents. So there's copies of bits of the newspaper included within the book and also on the website. And there's also links to Trove. So a student can go into and actually see that original Sydney Gazette. They can see the original Australian newspaper, the first one that came out in August, and they can see, the act. So we want them to actually see, no, these things really did happen. You can see the letter that Horton wrote to Darling and Forbes saying, do this, do that. So they can be transported and see it, these things, because they're all kept online so well, students can actually really embrace that and see it from all different perspectives.
Yeah, that's and how great it is to have all those things online and accessible.
Absolutely.
As well. Yeah, no, definitely. Okay, thank you. So our next question is, well, we've covered the title of the book a few times, but the title is Checks and Balances. And we've also spoken about the two concepts of freedom of the press and independent judiciary. So this is a question for Chris. Can you explain for us non-lawyers what these concepts are?
Well, freedom of the press, at its the crudest way of describing it, is the freedom of a publication to publish things that those in authority not just don't like, but are infuriated to see in print. That's the best definition. There was a newspaper before the one that caused all the trouble between Francis Forbes and Governor Darling. It was called the Gazette, as I recall, but it was effectively controlled by the government of the time, or the Crown, the governor. It was censored. It was not what we would consider to be a newspaper. It was a government information sheet. Is probably the most charitable way of describing it. So freedom of the press is it's very similar, if you think about it, very similar to the benefits of an independent judiciary. It's there to make trouble for those who cause trouble, if you know what I mean. The media highlights problems in society, runs debates, and that's exactly what the original newspaper in this story did. It was run by two very influential people, William Charles Wentworth and Robert, what's his name, Sally? I keep forgetting. Wardell. Now there's Wardell Chambers in Sydney and Wentworth Chambers in Sydney. These two fellows are effectively the founders of the private bar in Sydney. Wentworth was born in Australia to a convict mother, went to London to study law, met Wardell in London. Wardell, they were both barristers, but Wardell was also editor of a publication in London called The Statesman. He was also proprietor of that publication. However, he sold his interests, teamed up with Wentworth, got on a ship with a printing press, and off they went to Sydney and started the first real independent newspaper. And Forbes, it's basically due to Forbes that their publication survived. Now, had Forbes crumbled, the plan was to tax this newspaper and subject it to a licensing regime that would regulate its content, or in the end close it down, withdraw its license. Now, had that happened, the impact on the culture, the emerging culture of New South Wales and subsequently this entire nation, would have been, I expect, a little bit different. This country grew up with very little respect for authority. I think that's still in place. That's still pretty common. But just think it through. If, however, public debate was controlled by those in office, those in power, we would have turned out to be a very, very different place. And the same applies with public debate about laws, infractions of laws, abuse of laws. That it wouldn't exist. We would have become used to, we would have been a more compliant society. It's my personal view that we're still too compliant, but I fear that without the original newspaper, and it was called The Australian, there's no link to the current publication known as The Australian, this would have been a very different place. So it entrenched press freedom, made it clear that those in authority could not control the content of a free press. And the reason, I mean, hats off to English law. Whatever you think of the concept of colonisation, the reality is that English law was at such a state, such a position, that it would have been utterly repugnant for Forbes to have permitted the governor to close down or control the free press. So that's the significance of it in terms of press freedom. In terms of the independence of the judiciary, it's very similar. The outcome is very similar. It's an independent centre of power that holds those in authority in the end to account. Abuse of power, one way or another, could find itself under examination by an independent judicial officer who is not beholden to the governor or the government or those in authority in any way. And that's the system that we still benefit from in this country, state and federal. It's a rare thing. Most countries aren't like that. We've got a robust system of debate, and adversarial system where arguments are thrashed out in very blunt terms before courts, and that's how it should be. There's very little respect for the feelings of those on either side of the argument, and that too is how it should be. If questions of liberty or right and wrong are at stake, those arguments should be robust, and that's the system we inherited from Britain. And there might be problems in different aspects of the colonisation of this country, but when it comes to the legal system that they bequeathed us, there's absolute, its superiority over other systems is plain to see.
Thank you. Thank you for explaining that to us non-lawyers in the audience. There might be some lawyers, but thank you so much. And the next question, we might have touched on it a little bit already, but for Sally, could you share from the book or from your research why these concepts were so important in the early colony of New South Wales?
Yeah, well, Chris touched on it, that the these concepts were important because it shaped what the colony would end up being like. So when we wrote our first book, which was the first civil case about the cables, what was important about that is when they started a convict colony in 1788 that was predominantly made up of convicts, if they had the same rights that they had in England, they would not have been able to have a business, own property, take people to court, give evidence, sue, and do all these things. So what happened in the early colony is they made a decision that the convicts could have more rights than they did in England. What that enabled was convicts to have businesses. It actually enabled the society to thrive and actually to be self-sufficient. So much to the point that in the late 1800s, Australia was the wealthiest nation. It had the highest standard of living because the Australians and the convicts, and then those who got tickets of leave, could actually run a business and actually could have a life and know that that if they had property, it couldn't be taken from them because they could go to court and sue. So the first step in 1788 was the ability to run a business and to be able to go to court if someone took things, so you could own a property, own a house. And then the next step, what happened with what Chris was outlining, was to be able to have an independent judiciary meant that you could question the governor. So you could question if he gave land grants to his mates and if they were outside the law. So it actually suddenly started holding the governor to account, and it gave convicts, ex-convicts tickets of leave. It actually enforced this equality that we enjoy in Australia. So it enabled that. And we're hoping we'll write a next book about Mile Creek Massacre, because what's interesting is that's the next step in the development of the colony, which was Plunkett, who came from Ireland. He was massively into equality, and he fought for the Indigenous equality, which is the piece that we aren't talking about right now, is that not necessarily everyone had equality, but yet again, people came and went, no, everyone has to be treated equally and fairly, and you need the justice system to help you protect your rights. So that's how it's been important, because as Chris said, it's been enabled us to be where we are today, which would be a thriving economy, and we're safe in our homes and we can live our lives making decisions, not necessarily being directed by someone.
Thank you. Thank you. And Chris, the next question is for you, and I think you did touch on it, so I'll tell you what it is, and then you can let me know if there's anything else you'd like to add. But the question was, how could this story have turned out differently, and how would that have changed the colony of Australia and Australia today?
Well, let's do a counterfactual. Let's say William Charles Wentworth went to London, did his legal training, and decided he liked the rainy weather and never came home. The original Australian was never published, and the Sydney Gazette, this government newsletter, which didn't rock the boat, continued. It would have been a very tame cat sort of publication. Problems in public administration would not have been as brought to public attention, and there would have been less pressure on those in authority to fix errors in public administration or be sacked after those problems became apparent. So it's hard to imagine what Australia would be like without a robust free press, or if Francis Forbes had stayed in Newfoundland. You remember, this is not his first jog around the block. He'd been Chief Justice of the English colony of Newfoundland for some time before he came to Australia. So he had plenty of options. Had Australia received a more malleable Chief Justice as its first top judicial officer, public administration may have not been corrected when it ran off the rails. Excesses of power might not have been held in check. The the ability, all those things, free press and checks on power, allow pressures, social pressures, to be released. I shudder to think what would have happened had the legitimate expectations of former convicts for a return of their civic rights, had those legitimate expectations been ignored or not adequately addressed, there may have been civil disturbance. There was a little bit of civil disturbance in the early days of New South Wales, but there could have been more. These two things together made it apparent to a growing majority of people, and the former convicts were growing in number and in wealth throughout this period. They didn't go back. They made new lives in this country. And I'm proud to say that my antecedents are among them, quite frankly. And they wanted what they considered to be the rights of Englishmen. They didn't consider themselves to be Australians. They considered themselves to be British subjects. It's very, very similar. If you go back and have a look at the forces that led to the American Revolution, Benjamin Franklin, one of the American revolutionaries, he didn't start out as a revolutionary. All he wanted was responsible government under the British Crown. He wanted representation and the intransigence of the British government and the refusal to address the legitimate concerns of the American colonists led to the explosion that led to the American Revolution. And on one argument, you could say that these two factors led to the release of that pressure and made it possible for the local administration and the colonial authorities in London to recognise that, gee, we don't want to lose this lot of colonies as well. We'd better do something about their demands for civil rights. So in one way, you could argue that the American experience made it more likely that the British authorities would accede to the legitimate demands for civil rights of a growing majority of Australians who were suffering under the yoke of being a former convict and therefore deprived of all sorts of rights. Wentworth, one of his campaigns was to ensure that former convicts had the ability to sit on juries. Juries didn't exist, by the way, until he started campaigning. So that was one of his great successes. All these things came about not just through forces in this country, but it coincided with great reform movements in Britain, which made it very difficult for colonial authorities to resist this push fostered by Wentworth and Wardell and backed effectively by Forbes. So it was all a great coincidence, very lucky coincidence for this country, which I think on one view helped ease the passage, if you like, from an authoritarian regime in a penal colony to a robust, disrespectful democracy, which is what we've got today.
Which we're so lucky to have. Yes, exactly. And now we're going to just switch tact a little bit, and we've got another question for you, Chris. So we would like to ask a couple of questions just about current events and political implications. So the first question we've got is, how do the themes in this book relate to current global events and issues concerning free press and judicial independence?
Well, global events, the example I gave earlier about Elon Musk is the most recent. Any government that passes a law that can be interpreted as requiring a public servant to attempt to regulate the rest of the world, I think has overstepped the mark, and it was completely foreseeable that the federal court would point that out in a very well-mannered way and relieve Elon Musk of the terrible threat that a public servant in Canberra was going to chastise him. Had that happened, it would have brought Australian law into disrepute. It would have meant that our laws on what you can broadcast and see online would inevitably come into conflict with what other countries were attempting to do in their jurisdictions. So the United States, for example, would have an approach to regulating material or not regulating material online that would come into conflict with the approach favoured by, it was our e-safety commissioner who had the misfortune to be required to apply that law. So that would have eventually led to diplomatic differences and would have made Australian law a bit of a joke internationally. The rest of the world looking at Australia saying, you really want to regulate our what we can see online in our country? So the federal court did Australia a great favour by bringing a dose of reality. And what was the second part of that question?
The second part was, so the whole question was, how do the themes in the book relate to current global events and issues concerning press freedom and judicial independence?
Look, press freedom, it's always going to be a hot topic. The approach taken by Forbes, I hope, would be not forgotten by judges in this country. The Elon Musk issue is not the only problem or impending problem. Remember last year, the government unveiled plans to regulate what it described as misinformation and disinformation online. That sounds pretty reasonable. I mean, you don't want lies being told online, but if you look at the exposure draft of what they were thinking about, they've withdrawn this now and they're thinking about it again. But what they were proposing to do was to make it possible for another federal bureaucrat or a bureaucratic agency to order organisations, social media platforms, websites, to take down material that, in the view of this bureaucracy, this bureaucrat, was harmful. Now that's a pretty vague sort of term, which can vary from bureaucrat to bureaucrat, and is not the sort of way that you would normally describe a law that can lead to penalties of up to $1 million. So at the very least, that law is too vague to be applied properly. It doesn't give people much of an indication about what they can and can't do. And one of the principles of the rule of law is that the law needs to be clear so that you know how far you can go before you get into trouble. If the law, for example, said you can't put online acts of violence, that would have been at least a little bit better, but much of what you see online is violent. So my argument would be that a court would inevitably have to look at such a law if it comes up again. Now, there's no guarantee that it will come up again. I think what the government was trying to do in outlawing online harm, it sounds more like a political slogan rather than anything that you might find in a well-drafted statute. So if you look at statutes banning other conduct, it's extremely explicit so that there can be no doubt at all about what sort of conduct you can and can't do. So I think the courts have a role in preventing overreach by government agencies, even if they're doing what they think Parliament requires them to do.
Thank you so much. You've actually answered the next question I think we had down for you as well. So I really want to say thank you so much to both of you for providing such wonderful answers. I think I've learned more in the last hour than I've learned in the last little while. So thank you. We have a few minutes left for questions. There was someone with their hand up earlier, but I've noticed that their hand has gone down. But if anyone has any questions that they would like to ask Sally or Chris, we have a few minutes left over. You could either pop your hand up or using the emojis, or you can pop your question in the chat as well. I'm happy to read it out for you, or you can also, or I can invite you to read it or ask it yourself. I see that Jennifer has her hand up. Jennifer, would you like to unmute yourself and ask a question?
Yes, I would, thank you. However, mine's not a question, it's more a comment. May I congratulate both of you, please? And the reason I'm in Brisbane, but the reason I have such a great interest is I have just had an article published in the Queensland Journal of Military History called To Rid of Their Regiment, and it's the Sudds and Thompson story.
Oh.
Because whether you know it or not, it is Brisbane's 200th birthday this year as well.
Oh.
And Forbes came here in November 1824 with Governor Brisbane soon after his arrival. And I mentioned Forbes a heck of a lot. And of course, I've also written a book about this called Fettered Frontier, which that's my postcard of it.
Well, we can't quite see it with your background, but
that's a picture of the Brisbane River that Mr. Oxley has just found.
Oh.
Oh.
But at any rate, the reason I mentioned the book is because Brisbane History Group has kindly published it, and it's on their website, and it's called Fettered Frontier, and Forbes is one of my main characters. So I've worked on Sudds and Thompson and on Forbes, and Darling, of course, whom I think was anything but a darling.
So it seems.
And his handwriting really proves that, because he's one of the hardest handwritings to read with his annotations and things. But what you may not be quite aware is that Thompson ended up at Moreton Bay Settlement after it all. And he was here as a convict, and he was being guarded by his own regiment.
Oh, dear.
By Logan, and in 1828. And it said that a group of his fellow soldiers took him into the bush to leave him to his fate.
Oh,
according to official records, they just put down that he absconded. And but he managed to get back to the settlement and to the hospital and recover. And then in 1829, after being drummed out of the regiment, he was handed over to the regiment because they were about to go to India, the 57th again. But at any rate, he ended up being sent to Europe. And of course, as you will know from the subsequent court cases, they brought him from Ireland, from Sligo, to testify at Darling's next exposure in London. At the end of it, let me tell you, Darling got knighted, and Thompson, they didn't even hear his evidence. So it's all a fascinating story, all based on this freedom. And I very much thank you, because I wish I'd spoken or heard this before I wrote, because I would have stressed some angles more. But I do thank you for what you've presented.
Thank you so much, Jennifer. And how great to have you in the audience tonight. And congratulations on the book.
Thank you. Well, my other books on the female convicts of Moreton Bay and things are in the SAG library, and I will be Perry McIntyre, I'll get her when she gets back from Ireland to put one of these fettered frontier. I called it fettered frontier because the people who developed us were in chains, and we at that stage was the frontier for New South Wales Sydney settlement. So
thank you. When I'm back in the library next week, I think it is, I'll be going to find them.
and
Now,
I think the Queensland Journal of Military History may even be online.
Okay. Oh, good. Well, I might, I've written down the names of those. So if we send out the recording, we might send out the links to your books as well.
Thank you. That's very kind. But I just thought that they may just add to the story a little bit.
Oh, thank you so much for sharing. We've got a couple of other people with their hands up. So I think Lynn was next. Lynn Stewart. Lynn, if you want to unmute and ask a question.
Can you hear me? I have unmuted.
Yep, perfect.
Oh, good. I wanted to say that I think as complimentary as you are about W.C. Wentworth, I don't think it was he who I don't think it was because of what he said that we got a jury system. I think there was Gibbs, and maybe even before Gibbs, a jury system did come in, and there was a choice to a military jury or a jury of free people in men, of course, in New South Wales or in virtually in Sydney. But I did have a question for you about freedom of the press, and because in the 1830s and 1840s we had a lot of press in Sydney, and even though it was really quite a small town, a small city, it was the main means of communication, particularly, and it was the press was widely read by people who had an education and could read. So I would just wonder the move in Britain for freedom of the press, how long before the 1823 and when Francis Forbes was introducing the new 1823 Act, how long before that was freedom of the press really important in Britain?
Look, I haven't got any exact date, but 18th century coffee shops in London were a hotbed of public debate. Newsletters run by eccentric troublemakers were the forerunners to the tabloid press that you see today, or not just the tabloid press, all the printed press. So they were generally, as in the 18th century, 1 or 2 pages produced by those with a strong interest in public affairs or a single issue lobby group. And it grew from there. People distributed them for free, and then when the more popular ones took off, for a charge. So England's got a strong history of free speech.
We did a bit of looking to see if there was any links to the Magna Carta, because that's where we generally look back to. And of course, there's no freedom of the press in the Magna Carta. But I don't know. One of our researchers found information about the Star Chamber. So that's 200 years before this. The Star Chamber tried to actually control the newspapers, and they'd had a big fight about that.
Okay.
So the English were, from when we did a bit of looking at it, and I'm sure, and Chris is right, they had the papers, but I think before then, a bit like how when we tend to look at the Magna Carta, it's all adding bits and bits on. But when they settled Australia, they'd already had a lot of these fights. And so they knew it was in their lifeblood. Their birthright was the freedom of the press. It wasn't something like last week's problem. So all of those convicts who came on the First Fleet, they knew their birthrights, and they knew what had been fought 200, 500 years before. And one of those was with the Star Chamber, and that had been about press regulation. And exactly, from my understanding, is the story that they looked at the Star Chamber looked almost exactly what Darling was trying to do. Put a tax on the newspapers, tax on everything. So it was quite well established, is my understanding. Chris, you probably know the Star Chamber better than I do.
Yeah, look, it's not just the Star Chamber, but in the 19th century, they were not that far removed from, well, a century or so, or two, from the English Civil Wars and the Act of Settlement. And that put an end to the pretensions of the Crown to be absolute rulers. So that the people who colonised this country were aware that the mere fact that you represented the Crown didn't mean you were infallible, and you immediately had to pay homage. They'd had a revolution effectively, or not effectively, in reality. They'd had a revolution, they'd chopped off the head of one of their kings, and the king and queen who replaced them did so at the invitation of Parliament. So it was parliamentary sovereignty that was the dominant force at the time of colonisation.
How fortunate we were that happened, because it didn't happen in some other countries, as in France. So they ended up having a revolution, which Britain didn't have, because they'd already sorted that problem of the divine right of kings. They'd sorted it out earlier. That's how I see it, anyway.
Yeah, that's quite right.
And back to what we do is why do we try and teach kids about the Magna Carta and their rights? Is because they all protect you, and they actually stop us from a lot of riots because they protect our rights and they allow robust discussion. And that's why it's really important to understand the historical roots of some of our historical, our governance and our laws.
Yes, the independence of the judiciary, I think, is particularly important, and we see that it's assailed in some other countries, including the United States, where it seems that it's the Supreme Court or the High Court is up for sale.
Look, the American system is very different to ours. Many of the judges in the United States are elected. That's not the case in this country. Because of that, it's arguable that at least some of the judges in some jurisdictions, not all of them by any means, but are a little bit malleable. In my view, it's better for the common people, if you like, to have judges who don't owe allegiance to any political party or those in authority, are simply appointed to do a technical job, and their tenure is protected for, well, it used to be for life. I think it's now 72.
Yes.
So their salaries can't be reduced. So all those things add to the not invulnerability, but it makes judges far less likely to succumb to outside pressures. All those things are there not to simply placate judges and treat them as little gods, but to put a fence around them to ensure that those in power or very not just in government but in business too, there's very powerful businesses that might apply pressure on judicial officers or offer them a post-career appointment at a very significant salary. This explains why judges have got a generous public pension. They simply don't have to bother about all those things. The moral hazard has been removed, which is all these things go to prop up and protect judicial independence. And individually, there will be occasions when they might be questioned. No government likes to see its laws struck down. Nobody likes to grind. A lot of people grind their teeth when they become aware of how much judges make in office and in retirement. But the reality is that's the price you pay, or we pay as taxpayers, for a truly incorruptible judiciary. And you compare it to the legal systems in countries not too far from here, and it works. That's the bottom line. It's a price worth paying.
Absolutely. Thank you.
Thank you. And we've got one more hand up. I'm just mindful of the time, but we've got one more question, hand up, and one comment in the chat. So, Kerry, if you would like to ask your question.
Yeah, thanks very much. A fantastic discussion. Thank you both very much for that. I don't think we can possibly underestimate as a society the importance of the separation of powers and the rule of law. It's yeah, we'd be a dreadful place without it. I'm just wondering, I wasn't aware of the education centre, so that's a great discovery for me tonight. And I'm just wondering whether, does the Education Centre have any role in public advocacy, or do you have any resources aside from this fantastic book aimed at school kids? But do you have any sort of public community accessible resources?
So what we have is a website that has a lot of resources that look at rule of law things. So whether it is what is the independent judiciary, what are checks and balances, what are free press. It looks at we have case notes, and all of these are freely available. So, for example, we've done one on Baden Clay for Queenslanders. We have a lot on Chris Dawson of cases that help students and even society or the community unpack cases. So we've recently done a case note on a High Court case, the NZYQ, they're the right letters, case. So we have all those freely available on our website. And another thing we do is we, twice a year, we send out free poster packs to schools. So chances are if you go into a school in Australia, you'll see one of our posters on the walls, which will be about Magna Carta or about checks and balances. So we twice a year send free posters out to schools, and it has a huge uptake. And so it puts these concepts in really nice graphics, and you can see them all on our website. So we have everything available. And then we also have Chris, who writes weekly in the Australian, and you can also read those articles online with us as well. So they're all out there. It's just sometimes people don't find us. That being said, the teachers use us significantly. So we have a couple of thousand, 2,500 members who are all 70% of teachers. We have a really wide reach to the teachers. So that's a lot of people that use our material and know us. And we've been up to Queensland to conferences. Chris actually spoke last year at the Business Educators Conference. And so that's how we reach the teachers, as well as Chris writing his regular commentary.
No, that's excellent. Thanks. I'll enjoy spending some time looking at the website tomorrow. Thank you.
Yeah. Thanks, Kerry.
Thank you. And Sally, while you're on a roll, just the comment in the chat from Annesley. I don't know if you have anything else.
Sounds good to me. I don't know anything about the Peterloo massacre, so
no. Okay. We'll move on. We've just gone a little bit over time. So I just wanted to firstly thank Sally and Chris. What some of you may or may not be aware, we had a few technical difficulties to start off with, and they have been very patient with me tonight. So thank you so much for this wonderful presentation. I can see people clapping. As I said, I've learnt more in this hour than I've probably learnt in a little while. So thank you so much. I think it was great that it was so accessible, and you've made it so easy to understand and really fascinating. So I've got some homework to do, some reading that I'll be doing online. People are popping in. Yep, the link to Rule of Law is now in the chat. We'll be sending out the recordings, but thank you again to Chris and Sally. Thank you to everyone who asked questions tonight and who came along as well. We really appreciate your support. Happy Law Week. And Thank you. Yes, thank you for all the claps, and have a really lovely evening. Thank you for spending your Thursday night with us, and hopefully we see you at another event soon. Okay, thank you everyone.